The following presentation was made possible by the Alltech Media Group, a Southern California multimedia company providing exponential branding and marketing services to all their clients. The Alltech Media Group understands the value of the 3W strategy, providing their clients proven, trackable results. Let us make it easy for you to grow your business. Visit alltechmedia.com.
In part one of this program, we discussed some current issues facing EB5 and the changes that may ensue due to the SEC becoming more involved with the program. We now continue our dialogue with Michael, getting more in-depth on the SEC's active role in the EB5 program and why they filed a lawsuit against Intercontinental Regional Center Trust of Chicago, whose convention center project promised investors more than they could deliver. Can you give us your assessment of why the SEC recently got involved with shutting down the Intercontinental Regional Center Trust of Chicago?
Well, the reason they got involved was because somebody told them that there was concern about a problem. This is typically the way the SEC gets involved in a securities controversy.
Like a whistleblower.
Somebody says something weird is going on. Occasionally the SEC stumbles across something on their own, but for the most part, they are an agency that relies on other people whistleblowing, making a complaint, or another agency like USCIS calling them up and saying, gee, we're seeing some odd things in a particular project and the filings that the project is making to us with regard to the immigration side. Well, we're concerned about the business side, and we're also concerned about the security stuff that we're not expert in because we're an immigration agency, but you guys are, since you're the SEC. Here are our suspicions, do you agree? And obviously the agency did agree enough to launch an investigation, and that investigation caused them to bring the enforcement action that they brought.
Do you know what type of fraud the SEC reports that the Intercontinental Regional Center perpetuated against EB5 investors?
Yes, we've reviewed the complaint carefully. I would actually encourage all EB5 businesses to do the same so that they can better understand what sorts of things the agency is concerned about to the level that they will bring a lawsuit to enforce wrongdoing. But specifically, the SEC targeted the fact that that project was accused in the complaint. It's been accused. These are only allegations so far. Nothing's been proved, of course, but the allegations are pretty compelling that there were over-statements about the positive, there were under-disclosures concerning the negative, there was information that was included that was not entirely accurate, or it wasn't accurate within the context in which it was presented. Other information was entirely inaccurate, and then finally there are allegations of what I think you would consider not to be gray area fraud, but actual black and white fraud, that there were forgeries of documents, that documents were manufactured out of whole cloth, that they were represented to be official documents when they were not, either by a governmental agency or by a substantial business venture. So these are some very serious accusations of misconduct. The accusations aren't so much in the documents or the structure of the offering. It certainly is huge. It is a very ambitious project. I think that first caught people's attention when they looked at this and said, this is almost $1 billion project, of which $250 million was supposed to be raised from EB5. That's a lot of pieces. Mm-hmm. There was supposed to be bond financing, there was supposed to be government grant financing, and all of these things any one of them could go wrong, and what would the results be? Perhaps more catastrophic than has been described in the offering documents. So I think that's what caught people's attention, and the government did a very thorough investigation. If you look at the affidavits that are attached to the complaint, they've talked to experts in the hospitality industry, they've reached out to the hotel companies that supposedly were involved in this project, who said, in fact, they were not. So the government was very thorough, as the SEC typically is, before they actually file an action. They do their homework, and they went outside of the documents and went and independently checked to confirm that things were as they were stated in the offering documents, only to find out that they were not. And that's the basis of the SEC action.
Are they going to go to trial, do you think? Where are we at in the status of
Well, that's a great question. I'm not a litigator. It was many years ago that I was last in court as a trial attorney. But what I know of the process is likely that there will be a resolution short of some kind of settlement, other than taking the case all the way through to a verdict. It appears that the defendants are cooperating with the government. They're working together to see that the investors' funds are released from escrow and returned to them in order to minimize the damage to the investors. That's an important thing. If the defendants, I believe, had chosen not to cooperate, it might have been much more difficult for the investors to withdraw. They, in fact, might have been delayed another year or a year and a half until the litigation was actually resolved, which it hasn't been, before they could then be permitted to leave this investment and move to another. And in the EB5 program, timing is so important, especially when you have children that may age out and not qualify for participation in the EB5 visa, that those folks in particular would be really out of luck. I mean, if you're over 21, that's it. And so for some of those investors and their families, it might have been even worse injury on top of injury to have a delay in the return of their investment. So this is a very positive development. And I think it's a good indicator that the government and the defendants will reach a resolution. I think it likely that resolution will involve some significant sanctions against the defendants, especially since this is it's not the first SEC involvement in an EB5 transaction, but is certainly the largest and the most prominent. And I think that the SEC often wants to set an example and say to folks, look, we're serious about this compliance. It's absolutely essential that you do this and that you do it right. And if you don't, we're here to protect the investors, whether they're domestic Americans or immigrants, and make sure that the laws serve their purpose of protecting them against project principals who would take advantage of them.
How important is it to SEC that regional centers now make truthful statements and make proper financial disclosures about their proposed EB5 investments?
It's absolutely essential. It's also been essential before the SEC got involved, which is part of the reason why I and other securities attorneys have come into this industry. And along with the other lawyers in my firm, we've been advising clients, look, even though the SEC hasn't spoken yet, this was obviously prior to Chicago, you've got obligations that you need to satisfy, and we should assume that the SEC is watching, and that if they see noncompliance, that they will step in and say, hey, you're not following the law. And often they will, because of the nature of the fact that the SEC tends to be a reactive participant as opposed to a proactive. It usually hears about problems after the problems have happened, and then somebody brings them in because they've been injured or they think they've been injured. We said, look, let's not wait and have something happen that we can't repair, because by the time the SEC sees a problem, it's too late to fix it. So we want to head these problems off in advance by saying, look, honor your obligations under the law that exist whether the SEC is knocking on the door and saying they exist or not. So the obligation of regional centers and the projects in which they're looking to have investors invest is that they make full disclosure of all material facts about the investment opportunity that they're proposing or that they're marketing, in order that the investor, the prospective investor, can make the most fully informed decision about whether or not he should invest. In order for him to do that, he needs full information. And the information that he receives must be accurate, it must be truthful, it must be correct in its context, not just the simple statements. It has to make sense in the big picture. Otherwise, there can be liability, including serious, civil liability is what we see in Chicago, followed also by the prospect of criminal liability. So given that this is the obligation, and we've known about this obligation from the beginning, we're telling folks, don't wait for the SEC to arrive. You've got to do your duty and follow the law up front. Now, of course, 3.5 years later, the Chicago lawsuit gets filed, and we're able to say, well, told you so. This is what we were talking about, saying sooner or later the agency will arrive. And invariably, in every barrel of apples, there are some few, hopefully a minority, that are rotten, and those folks will get found. They will be caught by the SEC, and the SEC will go after them because the agency is very serious about ensuring compliance with the law. So it's going to happen. Of course, now it has.
Now, this year, since the Chicago case, we are hearing that SEC is strongly recommending that regional centers should fully disclose in their offering agreements and the actual payments that regional centers are making overseas to immigrant brokers. Why, in your opinion, is this important to the success of the EB5 program, and do you believe the regional centers should fully disclose these payments?
Well, absolutely we do. My firm, along with every other securities lawyer I know of in the industry, we may compete, but we're also colleagues, feels the same. That is that compensation to all persons who participate in a securities transaction, in the sale of an investment opportunity to folks who are not going to control their investment once they're in and therefore are at risk, you need to disclose the compensation of everybody who's involved and what basically they're going to get out of these investors. The government clearly said there was at the beginning of April, there was a webinar put on by the SEC in conjunction with USCIS. And there were about 5 staff attorneys from the SEC who spoke to everybody on the call. And they said very clearly their opinion, which to us is merely a restatement of existing law, that broker compensation is a material item in the mind of an investor. Think, if you know that you're making a $500,000 investment, maybe $550,000 if you add in an administrative fee, perhaps $600,000 if on top you also add the legal fee to the attorney for the immigration work. This is a huge financial investment being made by an investor. Would that investor be interested possibly in knowing that people who are responsible for selling him that interest and getting him involved are themselves going to earn somewhere between $100,000 to $200,000 over 5 years? If so, is the investor possibly wondering, gee, is this guy selling me on this deal because it's a real good deal for me, or because he's going to make a lot of money off me, whether the deal is good or isn't? So, of course, the answer is this is a material piece of information. The SEC was quite clear in saying what we had all been saying for a number of years, that the industry had basically been reluctant to comply with because overseas brokers have been very reluctant to have their compensation disclosed. Why? Perhaps because they feared exactly what the SEC states is the logic behind forcing the disclosure of compensation to be made, that an investor wouldn't like the fact that the brokers are making so much darn money and would question whether or not the sale of the investment is for the good of the investor or, again, for the good of the salesman. This has led to an increase now that the Chicago case has come out, that the SEC has made clear that this is a disclosure item. It's always disclosed in domestic transactions, and the SEC said, we see nothing about EB5 that would be different than that. So again, we're just doing the same old that we've been doing domestically forever. You're going to have to put this information into your offering documents in a form that gives the investor the opportunity to weigh the impact of the information on his or her individual decision. Reasonable minds may differ. I may say, okay, that's fair compensation, and I'll make the investment. And you might disagree and say, I think that's not a good investment, or I think that the salesman may be motivated by his compensation rather than that this is a good investment. And we're able to make our own decision. The government says, give the information so that people can make their own decision. We're not going to say whether or not the Chicago case would have been a good investment or would not have been a good investment. But you've got to discuss the investment openly, fully, and honestly. One of those disclosure items is the compensation. I think it's a great thing. Our firm believes that as a result of what is now increasing disclosure of broker compensation and the compensation of other folks involved in the transaction, marketing people and the like, there's going to be obviously more information available to the investor so he can make a better decision. Okay, that's certainly valid and vital. Also, I think there's going to be a reaction when that information is put out, because the investors are going to say, hey, that's a lot of money you're making. And I suspect over time we will see a reduction in the amount of money being charged to investors and to the U.S. business in order to get access to this capital. That will be good for the U.S. business. It may not be so good for the brokers, who have been getting extremely large compensation, especially recently. The trend has been not just this, it's been like this, for their compensation to increase. But I think that not only will the compensation start then moving downward for exactly the reasons the brokers didn't want to disclose the information in the first place, but also I think that my firm believes there's going to be more of a harmonization of what the fee is, that it's going to be more typically standard compensation. So you know as a businessman, and you know as an investor, I should expect to pay this. I should expect that the broker I'm talking to is getting that. So then I can decide, is he too motivated by money or not? And we see that coming. It's likely not to occur immediately. The SEC says, whatever you want to charge, we're not going to tell you what it is, but you got to tell your investors what it is, and then he can make up his own mind. But you got to tell him. So that rule, we believe, has been there from the get-go. It had not been very well followed because there was so much pressure coming from overseas agents who, without their assistance, you're not going to raise any investors if you're dependent upon their help. So a lot of U.S. businesses felt they were over a barrel and they had to go along with it. Well, now it's been made crystal clear that compensation needs to be disclosed. Huge change. And it's not the fault of the U.S. business, because the government is basically requiring it by saying, hey, we've been requiring this. You haven't been doing it. You got to get in compliance now. Going forward, you can never say, I didn't know anymore. Everybody knows. So the U.S. business says, we're not doing it. It's not our fault. Don't blame us, but we've got to disclose it. And everybody's going to have to disclose it, not just us. So there isn't going to be a competing project that won't, if they're honest. So I think that that is going to be the factor that causes greater disclosure, that the agents overseas are going to have to go along with, even if they don't like it. And as that information gets out and the investing world sees the amount of money, that they will react and put pressure. And therefore, that will bring down these huge fees for the brokers. That's good for investors, and it's good for the U.S. business. And ultimately, I think it's even good for the overseas agents, because those who are willing to establish a business that makes sense on reasonable commissions, that's a business that makes sense, not one that can exist only if it extorts people a ridiculous amount of money.
What advice do you offer to prospective EB5 investors about making sure that they receive full financial disclosures on these projects and payments made to immigration brokers?
I think the most important thing that an investor can do is what's called due diligence. That is to check into an offering opportunity to see if everything that is stated, or as much as is possible to check, is true or not. So, for example, if a representation is made in an offering that the investor is interested in, that the land for this hotel development has already been purchased, and the land is going to be valued at X, that's a contribution being made by the developer in addition to your money, well, it's smart for the investor to say, you're telling me you own the land, and you're telling me that it's worth X, where's the backup for that statement? And what we used to do was make the statement and say, here's the footnote, you can go look it up. But now we're trying to make it even easier on the investors, so we're either attaching backup information into the sets of offering documents themselves, or tell them if they're too voluminous or it's impractical, look, don't hesitate. If you have any questions, call us for backup. We can provide backup. And then for sure, if the government ever comes in and says, okay, you said you've got the backup, I know nobody asked, but I'm going to, because I'm the SEC, where's your backup? They are going to be able to produce the backup. So the investor should be working either on his own or, more realistically, with an attorney or an advisor of his own, checking the statements that are made in the investment opportunity documents to make sure they pass the smell test. Going to an accountant of their own to say, do these financial projections make sense given the industry, the size of the project, the location, et cetera? This is the due diligence process. Mm-hmm. Now, as securities lawyers, we occasionally assist investors in that process, in reviewing documents that somebody else generates about an investment opportunity, a US EB5 project, to help them understand if we think there are flaws or concerns. Our ability to do that is somewhat limited. We're only able to address what we see. Mm-hmm. We don't know what we don't see. We don't know if there's anything out there that hasn't been put in. So the ability is somewhat limited, but still we're able to render assistance to an investor to give them a more complete picture about whether or not there are obvious flaws. From our perspective, an accountant does his own perspective, an investment advisor from his own perspective, and those folks are invaluable to helping the investor make a better investment decision. Additionally, as attorneys mostly for the US issuers, the companies that are trying to raise the money, we're telling our clients, look, if we know that the investor world is going to be conducting more thorough due diligence on us, we've got to do our own due diligence to make sure we can withstand that scrutiny, or better put, I guess, so that we'll have the information available, either because we anticipated a question and we put the information into the offering documents from the get-go, or we attach the documents, or we've got the backup documents available upon request. So I think that has led to project documentation improving. Knowing that you're going to be scrutinized, and knowing that people are going to be nitpicking, because lawyers tend to do that, and those lawyers sometimes aren't just us working on behalf of a business as securities and corporate and transactional lawyers, but also securities litigators working either for the SEC or for the investor if he feels he's been taken advantage of down the road. We're saying, look, let's get out in front of this. Let's know that the world has changed. Put that information out so that when the advisors come in, whether they're attorneys, accountants, or investment advisors, they can look at this and say, you know what, it makes sense. Again, it's not a guarantee of success. And people are realistic, they're grown-ups, they're not looking for a guarantee of success, which is probably, it's not permitted under the EB5 program rules in any event, guarantees. But people are saying, look, I just want to know that this business has a reasonable shot of success. It has a good chance of getting the jobs. It has a good chance of being successful. That's enough. I'll make an at-risk decision. Without that kind of assurance, especially in light of Chicago that spooked investors everywhere, and rightfully so, the investors would say, I don't know that this isn't another Chicago about to happen. I'm not an expert, so I'm just not going to participate. That would be terrible for the industry, as well as for the prospective immigrants. So the fix is they have to get help and do better due diligence. The US side must do better due diligence, and there will be a meeting of both sides where the investors are going to say, you know what, I think they gave me, according to my expert advisors, everything I reasonably needed to know to confirm statements that were made, and even that projections, while not guarantees, are at least reasonably generated projections, so that they have some basis. They could actually happen. This is an investment I feel that I am making an informed decision about investing in, which is exactly what the SEC wants. So I think that kind of due diligence increase on behalf of all participants is not only something that the government welcomes, and USCIS as well as SEC, but also this is good for the American business, and it's good for the EB5 investor, and I think it's good for the EB5 industry.
Do you think those investors involved with the Chicago case, did they do their due diligence?
I suspect they did not. I suspect their agents did not. And this gets us full circle back to the conflict of interest about compensation of brokers. It has been believed, although the SEC did not target this particular point, but it's been believed that there were flaws in the project. Not the flaws that the principals would ever get accused of concocting documents, okay? No one knew about that. But in just the documentation that was prepared, there were concerns about whether or not it's viable, $1 billion project. Is that really viable? Very complicated financing structure with multiple offerings going on at the same time, with a very complicated capital stack that was heavily reliant upon bond financing from the state of Illinois. Isn't it broke? How realistic is that bond financing? There were a lot of questions that people should have had, that some did, but the investors evidently did not, because they all invested. And I mean, there's $150 million invested. That's 300 investors.
Yeah,
that's a lot of folks.
Mm-hmm.
So they thought it was a good investment.
Yeah.
Others did not, but those, I think that part of the reason why the investors chose to take the step was, first of all, there was no Chicago yet as a warning and a red flag on the road. Now there is. But also, those brokers were being paid huge commissions that were not told to the investors, of course, because the compensation wasn't being disclosed. So the investor didn't know that that broker, again, was selling him on something that he also didn't know was not a great investment or was a questionable, highly risky investment at best, and that that broker was making so much money. Did the broker know it wasn't a great investment? Was he savvy enough? If he wasn't smart enough to know, he shouldn't be selling an investment opportunity. Number two, if he did know, why didn't he tell me? Oh, because he's making $150,000 to $200,000 over 5 years? No wonder he didn't tell me. Mm-hmm. So that information came out, and everybody said, okay, we get it. We see what's going on. So they all stepped back and said, we don't want to invest unless things change. And of course, the government was saying, yes, things need to change, because we don't want to have to bring another lawsuit against folks who are right on the cusp of major fraud. Mm-hmm. There was only $11 or $12 million of all of these investors' money that was actually put at immediate risk. But there had been $150 million committed that was sitting in escrow that wasn't touched yet. Phew! Mm-hmm. So the SEC says, look, we're stepping in here to protect that money. We're not going to wait until it's 11 million plus 150 million that's been lost. We're stepping in now. That has made a huge impact, all for the better.
Thank you, Michael. Although USCIS administers the EB5 program, it is the job of the SEC to investigate, enforce, and bring action against those not complying with securities laws to protect investors. Michael believes their continued involvement will enhance the EB5 program. We hope you find our new educational dialogue series useful, and we look forward to bringing you more in-depth dialogues with information that'll help you make educated decisions about the EB5 visa program. I'm Amy Rios, and I want to thank you for watching our new dialogue series provided by EB5 Investment Report magazine.
The following presentation was made possible by the Alltech Media Group, a Southern California multimedia company providing exponential branding and marketing services to all their clients. The Alltech Media Group understands the value of the 3W strategy, providing their clients proven, trackable results. Let us make it easy for you to grow your business. Visit alltechmedia.com.